everybody, how you doing? Here's what I'm going to talk about today. There are lots of ways to buy a house. Somebody can come in and they can pay for it with cash. It doesn't happen a lot, but there are some people that do that. Most people just go to the bank and they get a loan and they pay for the house that way. Third way to do it, which some people do, and they do it for their own reasons, is they have the seller take payments and they do a transaction that's like a loan payment but without the involvement of a bank. A lot of people call this a seller carry finance transaction. I want to talk about those today because I know that there are people out there that are doing them. And why don't we start with the end result? You all know I'm a lawyer, and I'm going to tell you the obvious answer is that before you do one of these, come and see a lawyer. It's really important, but I'm going to tell you why too. So it's not that I'm just sitting here trying to run up fees. It's really important to make your transaction work right. First thing that I've got to talk to you about is this. The paperwork in these type of transactions is everything. If the paperwork isn't what your deal is, the thing is, if something goes wrong, courts don't care what your deal was, they care what the paper is. And if the paper's different, you have a different deal than you wanted. And it's not just words on paper. These documents are important and they have very specific meaning. So it's really, really important that you get the deal that you actually want. One of the things that goes in the paper is the description of the property, the legal description. And let me tell you something. Everybody uses an address to find a house or to find a building or to find the location. We all know that. In the eyes of the law, the legal address is absolutely meaningless. Take it from me. I'm the guy that took the case to the Idaho Supreme Court that came down and said that you have to have a legal description in all purchase and sale documents for real property, for land, for houses, and that an address is not it. A tax parcel ID is not it. Legal addresses have a very specific definition. Lawyers can help you make sure that you've got the legal description there. If you don't have the legal description, the document's not valid. The document's worthless. It's void. It's unenforceable. Let's talk about how you should set up a transaction where a seller takes payments. The best way to do it, for a lot of reasons, is to go ahead and have the seller be exactly like the bank. This is going to take certain documents. It's going to take a promissory note. It's going to take a deed of trust. It's going to be a situation where the buyer is actually the technical owner of the property while the payments are being made, and the seller has a lien to protect themselves. Why do you want to do it this way? Well, I'm talking to you from Idaho. So in Idaho, we have a procedure to protect and secure lenders who are loaning on land. And they get a lien on a document called a deed of trust. And this is a document that's designed to be foreclosed on fairly quickly if the lender isn't getting paid. This is why every single bank uses this process. So, if you're a seller and you're taking installment payments towards the purchase of your property, if the buyer doesn't pay, there's a process to go ahead and foreclose or collect on that money by selling the house. Under a deed of trust, it'll take you about 5 months and it'll cost you a couple of $1,000s. But as long as the house has equity, you'll get a chance to get that sold and get your money, or you get the house back, and other than waiting a few months, you're going to be okay. If you don't use a deed of trust, one thing that I've heard a lot of people try to do is they try and use what people will use various versions of it, but they'll say it's a lease purchase agreement. If you hear somebody use those words, get up and run the other way. Let me tell you why. Idaho has a law of constructive mortgage. What this law says is that if you put together some documents that look like they're trying to be loan documents on land, even if you're trying to do something else, we're going to treat them like loan documents on land. And it's not that you get kicked into the 5-month foreclosure process. You go into an older, classic version of a loan document, which is a mortgage. Here's what you have to do when you have to foreclose on a mortgage. You got to go to court. You got to file a case. You got to pay legal fees. I can tell you that the court calendars right now in the ordinary times are backed up about 18 months. The fees for a mortgage foreclosure will be 10 times what you're going to pay for a deed of trust foreclosure. And it's going to take you a lot longer. And get this, once you're done, you sell the property, that buyer gets 6 months to come back and undo the whole thing by catching you up. So don't do a lease purchase agreement. People will tell you they're quick. People will tell you you'll avoid foreclosure. People who tell you that are wrong. So I told you, you really want a lawyer on these transactions. And I'll help you out on that. I'll make it easy. I know some great lawyers that are able to take care of that. If you run into a transaction like this in Idaho, call us down at Hansen & Johnson. We've been doing this for years. We've got great lawyers that know the ins and outs of these transactions, and they'll help you out. You can reach us by calling 208-384-8588. You can reach us at our website, www.angstman.com, or you can send us snail mail. We're down at 199 North Capitol, Suite 200, Boise, Idaho. However you reach out to us, we'll be happy to set up an appointment and see what we can do to get you going on the right path. Good luck.